a privately initiated proposal is somebody who is soliciting. Mr. William Ruto went to India, met with this ADANI and told them, I am intending to do this, initiate it. What that means is that they exempted us from the advantage of the expression of interest. Because the expression of interest would have been carried in the papers for all and sundry to know, so that any person who is interested in that project can then bid. But you can see Mr. William Ruto Arap Sama decided to go to India and solicit for this particular engagement. Where does that leave transparency? Where does that leave the doctrine of accountability? Where does that leave the doctrine of the people's participation? Because at least you would have been able to know that the government is initiating this process and perhaps would have intervened at that particular time of the expression of interest stage. But the members who are concerned about the events that are unfolding in this country, state cannot be a state if it is not guided by the principles of the rule of law. We can only regard that state as a pariah state. Unfortunately, this country is slowly sliding into that pariah state due to the collapse and overwhelming collapse of the governing system and structures in this country. It's on that basis, therefore, after our previous space, that I and TG sponsored a public petition that is still doing rounds in our social spaces, and the petition itself is calling for a self-introspection of this country and the affairs of this country. Among them is calling Kenyans to rise up and call for actions, and especially in matters regarding the ADANI issue. Further to that, today we filed a constitutional petition in the Constitutional Court that is raising very weighty issues. If you've read the petition, it has captured two issues. One, we are making an assumption that the agreement and the consensus executions have been finalized. The other limp is we are making an assumption that they may be in a process of being finalized or executed. In all those aspects, when you look at the Constitution, it contemplates a scenario whereby one can move to court to uphold and protect the Constitution from violation on an anticipated event or an event that has already occurred. That is under Article 258 of the Constitution, as read together with Article 259 of the Constitution. And why are we doing this? We are doing this because we have a rogue government, a government that does not believe in the doctrines of transparency and accountability. If we were in a democratic state, that as perhaps people might want us to believe, this information would have been laid bare for all and sundry to access. But you can see the process is being held in a very clandestine manner, shrewd concealment of material facts, so as to frustrate any person who might want to go to file and carry that process. And that's why you saw the LSK and the human rights taking the procedure that they took. They took the procedure of judicial review, which is completely different from the procedure that we have initiated. The procedure of judicial review seeks or looks at interrogating the process of the decision making. Was it reasonable? Was it rational? Was it lawful? And that's why you can see the court granted them stay orders. And if you can look at those orders, the order speaks that leave shall operate as a stay. Meaning that due to the lack of the material facts, one may not be, they were not in a position to move through the constitutional mechanism to seek for declarations. Fortunately, we were able, TG was, and Mweru were quite instrumental in giving us the relevant information. As we speak, members must understand that this is not an anticipated issue. There is already existing feasibility study that was initiated and carried out by the ADANI group. That feasibility study was shared to me by Mweru. Secondly, it tells you if there is a feasibility study, then how was it initiated if the deal has not materialized? It tells you that the deal was consummated and it is at the process of the implementation. Subsequently, there has been an issue that was brought out by Senator Onyonka, that the question of the privatization of our airports and the other facilities like the KQ or the KAE, they have been subject of debate before the National Assembly. If you look at the report dated the 17th of June, 2019, when His Excellency President Uhuru Kenyatta attempted to privatize the same way William Ruto Arab Tamar is doing, you realize that the National Assembly deliberated over that issue and came to a conclusion that there are some strategic national infrastructures that attracts question of national security that you cannot either lease, privatize, or alienate them for whatsoever purpose away from the reach of Kenyans. That tells you the reason why Mr. William Ruto Arab Tamar is failing to initiate the process of approval by Parliament, because Parliament has already made that conclusion. And that brings me to the question that was put. The PPA and the question of public participation. We must all remember that the Public-Private Partnership Act is an amendment. And it was done and initiated by Mr. William Ruto Arab Tamar for purposes of making sure that he alienates strategic infrastructures away from the people of Kenya without their participation. If you look at Section 3 and Section 4 of that particular act, it has completely muted the voice of Kenyans. That Kenyans have no voice when it comes to the manner in which he chooses to implement the private-public partnership. And that is one of the gravagements that is pending before court. And that is why you realize that in all these halubalus and all these shenanigans, Kenyans have not been consulted. We have not been brought to the knowledge of what is happening. But you also realize that under Section 4 of the same Act, there is a proviso that Public Procurement and Disposal Act will also be applicable where the state itself has initiated some investment. ADANI are not coming to build a new airport so that then they can completely be precluded or excluded from the ambits of the Public Procurement and Disposal Act. They are coming to proceed or to carry on with a going concern perspective. And the Act says they cannot privatize anything under the Public-Private Partnership Act if the government itself has invested in that particular project. And that is why information is being concealed from us. And that is why we're asking the High Court to interpret for us whether that can actually be initiated when we Kenyans have invested in the construction of the airport. But the PPA contemplates a scenario whereby if the project itself is a new project, then there can be an initiation of the public-private partnership and exclusively for the benefit of the members of the public through various models. That is not what is with us today. And the model that is contemplated by the PPPA is either a BOOT, that is build, own, operate, and transfer, or a BOO, build, own, and operate. As we speak, we are not aware of the model that Mr. William Ruto Arap Tama has initiated. It tells you that it's completely be alienated from our reach. Further to that, our petition has raised another issue. When you list this petition, this airport for 30 years, and when you look at Article 10, which speaks about the doctrines of sustainable development, and when you look at the preamble to our constitution, which speaks about giving ourselves this constitution and the future generation, then you incorporate the two fundamental principles of intergenerational and intragenerational equity. Does the bill contemplate the inter and intragenerational equity principles when alienating this property? And if it does, how does it then square out for the period of 30 years? These are some of the issues we are raising in our petition. The other subsequent issue we're also raising is, can a strategic investment such as JKIA be alienated from the people without their participation? And if that so happens, what happens to the aspect and the idea of our sovereignty? Because our argument is that the JKIA and other airports domiciled within the republic are symbols of our sovereignty. So when you alienate them without involving the people, you're simply saying that you're compromising our sovereignty and our heritage. Those are some of the issues we are raising in that particular petition. But again, to go back to the question of the public participation and why the PPPA has deliberately refused to invite members of the public to give or to weigh in their view, through their views, is to make sure that we are kept out of reach of what Mr. William Ruto Arap Tama is doing. And I'm using the word Arap Tama deliberately. Tama meaning a greedy person. Because he wants to completely own everything in this country. So we are waiting and we anticipating that the court will render itself tomorrow for purpose of directions. But again, the deal as it is, and if you look at the feasibility study that was shared to us by Mweru, it tells you that these guys have advanced. For example, today during the strike by the workers at the airport, I have heard from the news that they have given documents in respect to that particular process or deal. Then it tells you that Arap Tama has advanced this deal to the exclusion of all Kenyans. That we're not going to leave as we are being forced to leave just because one person has decided to lead this country through his own whims, wishes, and aspiration. We'll keep on reminding Mr. William Ruto Arap Tama that this country must and will only be governed by the rule of law. We'll not allow the rule of men to govern us. And that's why you can see Section 5 was designed for a particular purpose. So that and of course you must remember that this act, the amendment of this act, came before the enactment of the Privatization Act. So they were focusing somewhere. So they are using parliament to legislate so that they can then steal from us. So the other weakest link that is existing in this country, that is perpetuating this mischief, that is creating the opportunities of Mr. William Ruto and his cadres to steal from us, is being facilitated by parliament through legislation. How would somebody legislate Section 5 in a free and democratic state and tell us that the provisions of that act will prevail? It will prevail as against which other act? If you look at Article 227 of the Constitution, that article does not contemplate an enactment of an act of parliament like the Public-Private Partnership Act that will compromise the principles of accountability, transparency, the rule of law, and all those aspects, and social justice. So Section 5 is designed to make sure that by the time we are done with Mr. William Ruto Arap Tama, you'll have confiscated all that which he thinks. And that is why you can see the media is reporting that the ADANI bill has ousted the jurisdiction of the court. They are saying that this bill must flow smoothly, must be immunized from public protest, must be immunized from being challenged in court, and that if we challenge it, there'll be damages accruing therefrom. But how can damages accrue from an illegality? If the contract was illegal ab initio, how will damages accrue? How can an agreement outlaw or oust the jurisdiction of the court? It tells you that the enactment of Section 5 was designed to make sure that these guys steal from us. Fortunately, that is one of the sections that we are challenging. The constitutionality of that section. Can it apply in the current existing constitutional dispensation? Those are some of the issues we have put and challenged the High Court to tell us. When you say that Section 5 the act will prevail against other acts, you can only say that the PPP Act will prevail as against the Public Procurement and Disposal Act. And if you look at the level of transparency being created by the Public Procurement and Disposal Act is so high as opposed to the Public-Private Partnership Act. Remember, ADANI says that this was privately initiated proposal. That tells you a privately initiated proposal is somebody who is soliciting. Mr. William Ruto went to India, met with this ADANI and told them, I am intending to do this, initiate it. What that means is that they exempted us from the advantage of the expression of interest. Because the expression of interest would have been carried in the papers for all and sundry to know, so that any person who is interested in that project can then bid. But you can see Mr. William Ruto Arap Tama decided to go to India and solicit for this particular engagement. Where does that leave transparency? Where does that leave the doctrine of accountability? Where does that leave the doctrine of the people's participation? Because at least you would have been able to know that the government is initiating this process and perhaps would have intervened at that particular time of the expression of interest stage. But we shall tell him and remind him again that Kenya will survive many of us.